criticism to him.
Well, in theory, we were.
We thought we were.
That's exactly
what I thought we were doing. Yeah, this chair.
Well, it's my honor to introduce you tonight our speaker, Professor Monroe Freedman. I could go on and on about who he is and his qualifications. I'm going to give you a very short introduction. Most of you know, Professor Freedman's work, but I did want to mention just a couple of things, especially for the students in the room, so that they can understand who it is that's speaking to them tonight. Just a couple of things. I want to mention one award that Professor Freedman won a few years ago. And then I want to read to you some comments that some of his peers have made about it. In 1998, Professor Freedman received the Michael Frank Award, which is the American Bar Association's highest award for professionalism. This award was created to acknowledge individuals whose contributions in the area of lawyers' professional responsibility set an example of insight into the demands of legal professionalism, dedication to the highest level of ethical conduct, and a vision of constant improvement of lawyer regulation in public interest. Professor Freedman received the award in recognition of a lifetime of original and influential scholarship in the field of lawyers' ethics. But to give you some more perspective of his influence, just a few comments from people whose names most of you will recognize. Professor Robert Rotunda has written that if we had to pick one person who created modern legal ethics as a serious academic specialty, it would be Monroe Freedman. Larry Fox. Professor Freedman is the conscience of our profession. William Simon. Suppose you had to pick the two most influential events in the recent emergence of ethics as a subject of serious reflection by the bar. Most likely you would name the Watergate affair of 1974 and the appearance a few years earlier of an article by Monroe Freedman. Of the two events, Watergate is the more famous, but the less important. And finally, from Alan Dershowitz, I regard Monroe Freedman as the Holmes and Brandeis of legal ethics. So please join me in welcoming Professor Monroe Freedman.
Thank you very much, Pat, for a generous introduction. And I don't want to seem ungracious, but you left out the thing I'm most proud of. And that is that I believe I am the only person who works in the ethics area whose work has been translated into Yiddish. And I know about this because a colleague, Eric Schmerz, was on a subway platform in New York City one day, and he saw us waiting for a train. He saw us standing next to him, an elderly Hasidic Jew, a man with black hat and payas and a long black frock coat, and he was reading the Jewish Daily Forward in Yiddish. It was open to the centerfold, 2 pages of solid Yiddish, and in the center, my picture. So Eric said to the man, "Excuse me, but what is that article about?" And the man looked at him and he said, "Why do you ask?" And Eric pointed to my picture. He said, "Well, I know that man." And the pastor said to him, "Is he a Jewish man?" Eric said, "Yes." He said to Eric, "Are you a Jewish man?" Eric said, "Yes." So, having established that it was all, as it were, within the family, the gentleman very solemnly tapped my picture. He said, "This man is full of shit." and just then, Eric's train came. So not exactly why, but you'll have about half an hour to find out. There was a case recently in which the court ordered the defendant to turn over his laptop so that it could be copied by the plaintiff's lawyer and an expert. And when they got there, at the appointed time, there was a 2-hour delay. And when they got the laptop, they found that it was hot to the touch and it was missing a screw from the hard drive enclosure, which made them suspicious. So the court ordered its own expert to examine the laptop. And the expert found that numerous files had been deleted and were unrecoverable, and also that there were numerous modifications in documents that were on the laptop. And so it was a magistrate judge. Magistrate judge entered a default judgment against the defendant for spoliation of evidence and attorney's fees to be given by the defendant to the plaintiff for the time involved in this fooling around. And one of the things that the judge said was, quote, "It is impossible to know what the plaintiffs would have found if the defendants and their lawyers had complied with their discovery obligations." Well, assume a similar situation, but the spoliation, in my hypothetical, is not discovered because of a court-ordered production, but it is found instead because the defendant sent discovery materials to the plaintiff, in which metadata revealed exactly the same thing, or a misdirected fax revealed the same kind of thing. Now, there are a number of court opinions and ethics opinions in this area, and a large number of them apply an exclusionary rule to the metadata or to the misdirected facts. The decision of a large number of these opinions is that the receiving lawyer cannot mine from metadata, cannot read the misdirected fax or email or whatever it may be, must advise the sender that it has been received, and must return it and not use it. Now, we're supposing it's exactly the same kind of thing as in the case that was decided recently, where it was court-ordered discovery, and the defendant had concealed information through spoliation. In that case, there was, and quite appropriately, I hope everyone would agree, severe sanctions. But if it happens the way I have just suggested, I think the majority of ethics opinions and court decisions exclude that evidence. In the dozens of ethics opinions and judicial decisions that I have read, a large stack of them, it's very striking There is discussion of confidentiality, lawyer-client confidentiality. There's discussion of dishonesty, that is on the part of the receiving lawyer who uses the information. There's discussion of prejudice to the administration of justice. There is discussion of professionalism, sometimes expressed as what goes around comes around. Professionalism being here a euphemism for putting the interests of yourself and your fellow lawyer ahead of your client's interests. What goes around comes around. You use what another lawyer has sent you through carelessness, and another lawyer someday is going to do the same thing to you. It's not in your interest to use this evidence of spoliation or the smoking gun that indicates some other kind of fraud on the part of the other side. There is almost no discussion whatsoever about the recipient's fiduciary obligation to his or her client, including loyalty, loyalty to the client, about which the model rules say loyalty is an essential element in the lawyer's relationship to a client. Very few of these dozens of opinions and ethics opinions, judicial decisions, talk about the importance of truth in the system of administration of justice. And the title of my talk is Whatever Happened to the Search for Truth. Incidentally, if anybody knows, I made whatever 2 words, and I saw it come back as 1 word, whatever, and I think it should be 2 words, but I'm not sure. So if anybody knows, I'm interested in finding out. But one exception is an article by David Mercer in 2006, in which part of the title is, I Can Tell When You're Telling Lies. But what follows from that? Too often what follows from it, well, I can't tell anybody about it. Does that make sense? Now, as a preliminary to talking about the search for truth and the importance of the search for truth in a lot of what we're going to be talking about in the next day, is that none of these opinions or decisions makes any reference to the fact that the lawyer is the client's agent. And this is a truism that is universally recognized. Lawyer is the agent for the client. Now, to understand my point, take an actual case where a lawyer picked up his voicemail one morning and found on it, this was a defense lawyer in a personal injury case, and found on it a message from the plaintiff himself, who thought he was calling his own lawyer and somehow had called the defense lawyer. And what he said was, hi, so-and-so, I wanted to ask you, is it okay if I shoot some baskets with the guys? I want to ask you because, this is a total disability, personal injury case. I thought I should ask you because you got so angry with me when I went bowling. Now, do you have any question? Does anybody have any question about whether that admission by the plaintiff can be used? doubt it. Why is it different then? If the same kind of information comes in a misdirected email or in data that has been mined or a misdirected fax from the lawyer for the plaintiff, saying, for example, I understand you went bowling. If you ever do anything like that again, you're going to have to find another lawyer. I have told you they're going to be watching, so and so. Why should that not be usable? Just as much as when it comes from the client, the principal himself. Take a Supreme Court decision in a death penalty